Morning.
Good morning.
You can hear me in the jail?
Yes, ma'am.
Oh, on the record in the matter of the people of the state of Michigan versus Dante Robinson, file number 24-01641, counsel appearance.
Yes, Assistant Public Defender Scott Nickel on behalf of Mr. Robinson for arraignment this morning.
Okay, you're Mr. Dante Robinson.
Yes, ma'am.
Mr. Robinson, I have here a felony complaint. It alleges that on or about the time frame of April 16, 2024 through April 22nd, 2024, the area of 6111 Balfour, that's in the city of Lansing, Ingham County, state of Michigan, that you did allegedly commit the act on or about April 17, 2024, home invasion second degree, and that you did break and enter or enter without permission a dwelling located at 6114 Balfour Drive, Lansing, Michigan, and while entering, present in, or exiting the dwelling did commit a larceny contrary to Michigan compiled law 750.110A3. Count one is a felony. The maximum penalty is 15 years in prison and or $3,000 in fines. There's also a count two of on or about April 17th, alleging a larceny in a building. The allegations that you did make or commit a crime of larceny in a house by stealing a hat and a cell phone, contrary to Michigan compiled law 750.360. That's a felony, maximum penalty, 4 years and or $5,000 in fines. There is a count three on or about April 16th through April 2022. Allegations are that you did engage in aggravated stalking and that you did engage in a willful course of conduct involving repeated or continuous harassment of a Victoria Maynard, the conduct being such that will cause a reasonable person to feel terrorized or frightened or intimidated or threatened or harassed. Said conduct actually causing Victoria Maynard to feel terrorized or frightened or intimidated, threatened or harassed. And the course of conduct included the making of one or more credible threats against Victoria Maynard, and this was done contrary to MCL 750.411I. That's a felony, maximum penalty, 5 years and or $10,000 in fines, probation for any term of years not less than 5 years. Count four, weapons, firearms, possession by prohibited person on or about April 16, 2024, alleging that you did possess a firearm when ineligible to do so because you had been convicted of controlled substance possession of methamphetamine or ecstasy, a specified felony that is punishable by imprisonment for more than 1 year. And the requirements for regaining eligibility had not been met, contrary to MCL 750.224F6. That is a felony, maximum penalty 5 years and or $5,000, mandatory forfeiture or weapon or device required by law. Count five, assault with a dangerous weapon, also called felonious assault, alleges that you did make an assault upon a Victoria Maynard with a dangerous weapon, that being a handgun, but without intending to commit the crime of murder or inflict great bodily harm less than the crime of murder, and that this is contrary to MCL 750.82. That's a felony, maximum penalty, 4 years and or $2,000 in fines. DNA is to be taken upon arrest and a consecutive sentence may be imposed if the assault was committed in a place of confinement. Count 6 and 7 are both weapons, a felony firearm, alleging that you did carry or have on your person or in possession a firearm, that being a handgun, at the time that you committed or attempted to commit. Then count 6, it was prohibited person in possession, and in count 7, it was assault with a dangerous weapon, and that these were both done contrary to MCL 750.227B. Count 6 and 7 are felonies, maximum penalty 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. And then there's a mandatory forfeiture of the weapon or device required by law. There's a habitual offender notice here, third offense notice. It says, take notice that the defendant was twice previously convicted of a felony or attempt to commit a felony, and that on or about February 15, 2017, he was convicted of the offense of domestic violence, third offense in violation of MCL 750.814 in the 30th Circuit Court for Ingham County, State of Michigan. And that on or about June 12, 2023, he was convicted of the offense of controlled substance meth ecstasy in violation of MCL 333.74032BI in the 56th Circuit Court for Eaton County, State of Michigan. Therefore, a defendant is subject to the penalties provided by MCL 769.11. That enhances your maximum penalty to twice the maximum sentence on the primary offense or a lesser offense. The maximum penalty cannot be less than the maximum term for the first conviction. Do you understand everything that was read there, sir?
Yes, ma'am. Ladies.
State of Michigan versus Dante Robinson, file number 24-00969. I have here a misdemeanor complaint. That complaint alleges that on or about January 23rd, 2024, at the address of 6111 Balfour Street, City of Lansing, Ingham County, State of Michigan, that you did allegedly commit the act in count 1 of domestic violence. The allegations are that you did make an assault or assault and battery upon a Victoria Maynard, an individual with whom you had a dating relationship, and that this was done contrary to Michigan Compiled Law 750.812. That's a misdemeanor, maximum penalty 93 days in jail and or $500 in fines and a consecutive sentence. Is there something behind you that you need to address? Because we can come back to you if you're busy.
No, no, ma'am.
Okay. So then you should be paying attention to me.
I apologize.
Okay. The maximum penalty, again, 93 days in jail and or $500 in fines. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There is, however, a second offense notice attached to count 1. It says, take notice that the defendant was previously convicted of assaulting or assaulting and battering his or her spouse or former spouse, an individual with whom he had a dating relationship, an individual with whom he had a child in common, or a resident or former resident of his or her household, or of knowingly assaulting a pregnant individual by violating Michigan Compiled Law 750.813 on or about February 15th, 2017. And therefore, upon conviction, will be subject to an enhanced sentence under MCL 750.814 that makes count 1 maximum penalty 1 year and or $1,000 in fines. Do you understand the charge that was read in the maximum penalty there?
Yes, ma'am.
The State of Michigan versus Dante Robinson, file number 24-02032. Again, another misdemeanor complaint that alleges that on or about June 15th, 2024, at the area of 6111 Balfour, City of Lansing, Ingham County, State of Michigan, you allegedly committed the act of domestic violence against Victoria Maynard, a person that you have a dating relationship with. There's a second offense notice attached to this as well, which would enhance the maximum penalty in this matter to a misdemeanor, 1 year and or $1,000 in fines. You understand the charge, the maximum penalty there?
Yes, ma'am.
Okay, in each of these matters, you have the right to be represented by counsel. You're represented today by Mr. Nickel from the Office of the Public Defender for the purposes solely of your arraignment. You have the right to be represented by an attorney at each stage of the criminal prosecution, and if you're questioned by law enforcement. If you cannot afford to hire your own attorney, you can make a request to have the Public Defender's Office represent you at the expense of the public. Do you understand that?
Yes, ma'am.
Is he making a request for the Public Defense Office to represent him?
Yes, he did, Your Honor.
Okay, you have the right to remain silent, Mr. Robinson. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, this matter will proceed all the way to a trial. You have one file that's being charged as a felony. That's file number 24-01641. So in that file, you have the right to a preliminary examination. You have the right to have that examination within 21 days of the date that you're arraigned. So that's 21 days from today's date. That timeline is set unless you waive the 21 days or the court finds good cause to go beyond the 21 days. At the time of your preliminary examination, you have the right to require the prosecution meet their burden of establishing that they have sufficient probable cause that a crime was committed, and then probable cause sufficient to charge you with those crimes.
Okay.
You understand your right so far?
Yes, ma'am.
Okay, you are currently scheduled for probable cause conference for me, Judge Kristen Simmons. It's going to be on September 13th at 9 o'clock in the morning. You have a preliminary examination before me in person at the court. September 20th at 9 o'clock in the morning. You should have received a notice to appear for those dates. Did you get a notice to appear for that? You didn't get any notices to appear, sir?
Just to appear right now.
So she said on the 13th.
Oh, right here, 13th and the 20th. Yes, ma'am.
Okay, very good. And file number 24-00969 and file number 24-02032. Those are both misdemeanors, so you do not get a probable cause conference. You'll have a pretrial on those. Let's see. One of those matters is scheduled before me. That's file number 24-02032, and that's scheduled for September 17th at 8:30 for a pretrial before me. Your other file, 24-00969, was somehow scheduled before Judge Flores, and that's going to be September 23rd at 9. That'll likely be changed because you have more than 3 open cases before me at this time, okay?
Okay.
So we'll probably get that one transferred to me and have it set for the 17th of September so that you can have both of those run at the same time, since it's the same alleged victim as well. Let's see
Okay.
here. Okay. If these matters, or actually all these matters, you have the right to proceed to a trial, and you have the right to jury trial in each of these files. At the time of your jury trial, you enjoy the presumption of innocence. So that means that you're innocent until proven guilty. You have the right to require the prosecution prove your guilt at trial by proving each element of the charges being brought against you beyond a reasonable doubt. You have the right to remain silent at your trial and not have silence be used against you. You can waive your silence and testify on your own behalf if you'd like. You have the right to subpoena witnesses to trial that will testify for you and present evidence that you believe show a defense to the charges being brought against you. And you have the right again to require the prosecution prove each element of the charges of each of the files being brought against you beyond a reasonable doubt at your trial. You have any questions so far?
No, ma'am.
Okay, for the purposes of today's arraignments, we'll enter not guilty pleas on each file. I have to mix all this stuff up. Let's see here. Where are you employed?
The lug nuts. And I was just about to start at the Lansing Center.
Okay, what's your home address?
907 Clyde.
Spell that.
CLYDE.
In Lansing?
Yes, ma'am.
What's your phone
48915
What's your
517
phone?
202 6045.
Are you currently on probation or on parole?
I'm on probation.
Before which court?
Eaton.
When were you placed on probation in Eaton County? You don't remember?
No.
You can address bond counsel.
Yes, Your Honor, I did have a chance this morning to speak with Mr. Robinson. He informed me he is employed at the Lugnut Stadium. He's lived in Lansing his whole life. He's never failed to appear for a court date. He did notify me he was on probation in Eaton County. Looks like he was placed on that probation June 12th of last year.
I'm sorry, I have to stop you. You said he never failed to appear for a court date.
That's the information he provided me.
Well, he must have forgot that he's in warrant status on file number 23-03626. Before me, he failed to appear for his trial since March.
I had told you that I came late to a court appearance, and they had already sent the warrant when I got there.
He did mention to me being
since March. It's been in warrant status since March, but he had a jury trial set for April 2nd. He didn't appear for that either. This is not him coming late. He didn't come at all.
understood, Your Honor. As he is on probation, looks like felony probation in Eaton County, I would expect at some point he will have a probation hold on him. I'd ask the court to set reasonable cash surety or 10% bonds in each of these files.
I had a concern when he told me he was on felony probation. How I don't know how you can be on probation and they see that you have a warrant and you don't come and take care of it. It makes no sense to me. I also have a bond recommendation here in the new felony file, and the concerns indicated here are some factors indicating an issue with the protection to the public. It says defendant is currently on parole, probation, or has pending criminal charges. We know there's at least 2 of that because he's on probation. And I have 4 files in front of me right now. 3 of them he just was arraigned on. This crime, the felony one, is a charge involving violence towards another person. It says that the charge involves possession of a firearm, and the defendant has a history of behavior directed toward the victim. It also indicates a history of threatening or harassing behavior toward the victim or witnesses, and that there was an intimate partner relationship. It indicates that there was some risk of lethality with some threats to kill victim or the family, some stalking behavior, an escalation of violence over time. Defendant is on felony probation out of Eaton County and continuously stalk and threaten the victim, it says. There are audio recordings of the defendant admitting that he stole from her house and that there is a video recording of him doing so. It also indicates in the bond recommendation that he has threatened to kill her, threatened the lives of other people she knows, and he has threatened to show up to her job and harass her there. The prosecution's office is requesting a cash surety bond of $125,000 with GPS tether and exclusion zones, and that include where the victim resides and works, and notification if possible, and a no contact order for the victim and a individual by the name of Gilbert Hardgrove. Based on the information provided in the bond report, as well as the information in the affidavit of probable cause, the fact that you have 4 pending cases now before this court, you're on felony probation, and you have been in bond status before my court since April, and it's now September. You will not get a PR bond because there is a risk of flight, but the concerns is that there's a escalation of violence and violent nature, even as the charges, the first charge you had before me was an assault and battery, and now I have a home invasion, assault with a deadly weapon, stalking and weapons charges that you have pending now. The court's going to grant the prosecution's request for a high cash surety bond. Bond will be set in the amount of $125,000 cash surety with GPS tether.
Man, I was just with this lady yesterday.
I'm sorry, I don't understand what you said.
Don't repeat that. Your Honor, is Miss Maynard also the victim in the file that he FTA'd for?
It's not, it's a different victim, and I'm gonna arraign him on the bond violation in just a moment.
Okay.
Which is my sister, Mayor Robinson.
Okay, file number 23-03626 is the matter that you had with a pending assault and battery before me. You saw me back in February 19th. There was an offer for you to plead guilty to disorderly jostling. The matter was scheduled for final pretrial and jury trial. You failed to appear for both. So the matter's been in bench warrant status. The new allegations would trigger or has triggered a bond violation. And that is because your conditions were that you were not to be in contact directly or indirectly with the Renee Robinson Beasley. I have a police report 24519088453 from the Lansing Police Department, dated September 1st, 8:00 p.m. at the area at or near Oakland and Westmoreland, that indicated that there was a violation of that no contact order. And so you have the right to have a contested hearing, because they know the bond violation would trigger a contempt of court. Contempt of court for your bond violation is punishable with a maximum penalty of 93 days in jail and or $7,500 in fines. You understand your right to have a contested hearing for the bond violation, sir?
Yeah.
Okay, you have the right to be represented by your attorney. I don't recall who your counsel was on this matter from the public defender's office. Mr. Nickel probably could best advise who's representing you on that.
Here's that it's Jacob Raleigh from our office.
Okay. The court will enter a plea of not guilty on your behalf for the bond violation, and that will be set for hearing. Okay. File 23-03626, which is the matter that you just had the bond violation for. I gotta give you a new bond now. Your bond was previously 500 personal recognizance with the no contact order. I will issue a bond of $500 cash surety on that file. File number 24-00969. Bond is set in the amount of 2,500 cash surety with GPS tether. And file number 24-02032, bond again is set at 2,500 cash surety with GPS tether. The three files that you were arraigned on has the same victim, Victoria Maynard. There's a no contact order. You're not to have contact directly or indirectly with Victoria Maynard. Do you understand what that means?
Yes, ma'am.
So while you're in jail, I would remind you that the jail calls are recorded and the Ingham County Prosecutor's Office will listen to your jail calls. They will also be able to determine if you are calling from another inmate's number. They'll also be able to determine if you are having family members contact on your behalf. So again, I'm going to remind you, no third-party attempts to make contact with Victoria Maynard is allowed while you're on bond or in custody at the jail. There's also not to have any contact between you and a Gilbert Hargrove while on bond on file number 24-01651. Do you have any questions about that?
No, ma'am.
Also, while on bond, You're not to use, purchase, or possess alcohol or drugs unless you have a valid prescription. You're not to travel outside the state without prior approval of the court. You're not to possess a firearm, ammunition, or weapon of any kind. You're not to engage in any assaultive or threatening behavior. You need to report to pretrial services within 48 hours of your release on file number 24-01641. Do you have any questions about your bond conditions?
No.
And lastly, you need to make sure you appear for all of your court dates. Any additional matters for the record, counsel?
Nothing further for the record, Your Honor.
Okay, you're all set, sir.
Your Honor,
Yes.
bond condition with him as well, or no?
I couldn't hear you.
Was there a PA 53 for him as
There
well, or
wasn't.
no?
Yeah, I just arraigned him on the PA 53. The PA 53, the file is the file that he's on, that he had a bench warrant for me on.
Okay, I'm sorry, I missed the bond on that.
That's $500 cash surety.
Okay, thank you.
No problem. On the record in the matter of the people of the state of Michigan versus Raymond Tols, file number 24-02278. Council appearance.
Put your hoodie down and right at that table.
Yes, Assistant Public Defender Scott Nick on behalf of Mr. Tols for arraignment today.
Okay, you're Raymond Tols.
Yes, ma'am.
Okay, Mr. Tols, I do have a misdemeanor complaint here that alleges that on or about July 31st, 2024, at 2100 Bill Avenue, City of Lansing, Ingham County, State of Michigan, that you did allegedly commit the act in count 1 of domestic violence. The allegations are that you did make an assault or assault and battery upon an Ashley Peters, a resident or former resident of your household, and or an individual with whom you had a dating relationship, and that this was contrary to Michigan Compiled Law 750.812. That's a misdemeanor with a maximum penalty of 93 days in jail and or $500 in fines. There is a second offense notice though, so that would enhance the sentence. It says, take notice that the defendant was previously convicted of assaulting and battering his spouse, former spouse, or individual with whom he had a dating relationship, an individual with whom he had a child in common, or a resident or former resident of his household, or of knowingly assaulting a pregnant individual by violating MCL 750.814 on or about May 13th, 2013. And therefore, upon conviction, will be subject to an enhanced penalty. Maximum penalty for count 1 now would be 1 year and or $1,000 in fines. There's a count 2 of assault or assault and battery, alleging that you made an assault or assault and battery upon a Kristen Thomas, contrary to MCL 750.81. That's a misdemeanor. Maximum penalty is 93 days in jail and or $500 in fines. A consecutive sentence may be imposed if the assault was committed in a place of confinement. Do you understand both charges and the maximum penalties attached?
Yes, ma'am.
All right, you have the right to be represented by counsel. Mr. Nichols is going to represent you today for your arraignment. However, you have the right to have an attorney represent you at all of your court appearances and represent you if you're questioned by law enforcement. If you can't afford to hire an attorney, you can make a request today to have the public defender's office appointed to represent you. You understand your right to counsel, sir?
Yes, sir. Ma'am.
All right. You have the right to remain silent. Anything that you say, anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, the matter will continue all the way to trial. You have the right to jury trial, and you have the right to the presumption of innocence. So that means you're innocent until proven guilty. You have the right to require the prosecution prove your guilt at a jury trial. They'll have to prove each element of the charges being brought against you beyond a reasonable doubt. You have the right to remain silent at trial and not have silence be used against you. You have the right to see, hear, or question any other witnesses that the prosecution calls to testify against you. You have the right to call witnesses or subpoena witnesses to testify on your behalf, or you can waive your silence and testify for yourself at trial if you like. You understand those rights?
Yes, ma'am.
Is he requesting court-appointed counsel?
He is, Your Honor.
The court will enter a plea of not guilty on your behalf. I have an address for you on, it's a Carino Court. Is that accurate?
Yes, ma'am.
What's your phone number?
517-410-6069.
Are you employed?
Yes, ma'am.
Where?
Amazon, Upper Court Road.
Are you currently scheduled for pretrial conference before me, Judge Kristen Simmons? It's going to be on September 17th at 8:30 in the morning. Did you get a notice to appear?
Yes, ma'am.
Are you currently on probation or parole?
No, ma'am.
Okay, counsel, you can address bond.
Yes, Your Honor. I did have a chance this morning to speak with Mr. Tols. He does appear he has that one prior domestic violence conviction. Did not report that he had ever failed to appear for court date. He has an address he can reside at on Carino Court, where he will reside with his mother. It's my understanding Ms. Peters does not reside at that address. And so he should be able to comply with the no contact order. I did review with him what the conditions of the no contact would be and the consequences of violating. I expect that he will follow it. I would ask that the court release him on a personal recognizance bond at this time.
Thank you. My records indicate he has a bench warrant right now for 56A District Court, so he's going to be remanded to take care of that.
What is that?
You have a bench warrant for 56, that's Eaton County. It's for a charge of a stolen property. Allegedly been in warrant status there since April.
I've been, may I say something or no?
You can.
I got pulled over by Lansing Police Department and they had told me they didn't want me for that warrant, so I didn't comply with it or whatever going to them. But I had got pulled over by Lansing Police Department and they had called Eaton County and they didn't take me when I got pulled over, so I didn't take an order because that stuff wasn't, I didn't do that stuff. I was in Texas. I got a Texas ID for the stuff they're trying to get me for. And I wasn't here.
But you clearly were advised you had a warrant and you didn't go take care of it.
They didn't tell me I had a warrant. They said they didn't want me, so I didn't go over there.
What do you mean? Who said that they didn't want you?
Lansing Police Department had called Eaton County when they pulled me over.
time when I was with Ashley Peters and we didn't have this happen. They took Ashley Peters to jail and they asked if Eaton County wanted to come pick me up, and they said no. And I was like, okay, well, it's not bad. So I'm not going to do nothing. I'm going to continue going to work. And I was going to pay on a payment plan with them. Huh?
Well, that's not what your criminal history says. Your criminal history says that you have a bench warrant that's been issued. So you need to get that resolved. Nonetheless,
I will.
your bond on this matter is going to be set at 2,000 cash surety with GPS tether.
Wait, what?
There's a no contact order. 2,000 cash surety with GPS tether. Did you hear me?
Yes, ma'am.
Okay, where are you looking behind you?
I don't know what that. I don't understand that, but I'll take it. Okay.
You don't understand what 2,000 cash or surety means? Is that what you're saying?
Ma'am, I can't afford that right now, but okay.
You can pay 2,000 cash, or you can get a bondsman.
Okay.
Okay. There's also a no contact order. You're not to have contact directly with or indirectly with Ashley Peters or Tristan Thomas.
Okay.
Do you know what directly or indirectly means?
Indirectly means I can't talk to her no more.
Well, indirectly would mean you can't send a message through anybody else or through any other means. Directly would mean you can't talk to her at all, personally. So you can't text her, call her, message her, write her a letter. You're not even to be within 1,500 feet of wherever she lives, works, or goes to school. Do you understand that?
Yes, ma'am.
You also need to report to all your court dates on time. You're not to possess a firearm, ammunition, or weapon of any kind. You're not to travel outside the state without prior approval from the court. You're not to engage in any assaultive or threatening behavior. You cannot use alcohol or drugs unless you have a valid prescription. Do you have any questions? Do you have any questions, sir?
Oh, ma'am.
Any additional matters for the record, counsel?
Nothing further, Your Honor.
You're all set, Mr. Tols.
Oh,
Okay, on the record in the matters of the people of the state of Michigan versus James Felton, I have file number 23-02772 FY, and then a new file. Counsel appearance.
Assistant Public Defender Scott Nickle on behalf of Mr. Felton.
Mr. James Felton?
Yes, ma'am.
Okay, Mr. Felton, and file number 23-02772. I have a felony complaint here that alleges on or about August 1st, 2023 at 3922 Hartford Road, apartment 14, City of Lansing, Ingham County, State of Michigan, that you allegedly committed the act in count 1 of interfering with a crime report, committing a crime or threatening to kill or injure. The allegations are that you did, through the unlawful use of physical force, prevent or attempt to prevent another person from reporting a crime committed or attempted by another person, and that the violation involved committing or attempting to commit the interference of electronic communication against a person, and or did retaliate, attempt or retaliate, or threaten to retaliate against another person for having reported or attempting to report a crime committed or attempted by another person by committing or attempting to commit interference with electronic communication contrary to MCL 750.4A32B. Count 1 is a felony. The maximum penalty is 10 years in prison and or $20,000 in fines, and a consecutive sentence may be imposed for any other conviction. There's a count 2 of assault with a dangerous weapon. That's called a felonious assault. It says that you did allegedly make an assault upon a Victoria Velez with a dangerous weapon, that being a knife, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder. This is contrary to MCL 750.82. It's a felony. Maximum penalty 4 years in prison and or $2,000 in fines. Count 3, interfering with electronic communications, alleges that you did willfully and maliciously prevent, obstruct, or delay by any means the sending or conveyance or delivery of an authorized communication by or through a telephone or telephone line, contrary to MCL 750.5405A. That's a felony. Maximum penalty 2 years and or $1,000 in fines. Count 4, domestic violence, alleges that you did make an assault or assault and battery upon a Victoria Velez, an individual with whom you had a dating relationship, and that this was done contrary to MCL 750.812. Restitution may have been ordered, as this may have resulted in damage to another individual's property or physical injury or death to another individual. The maximum penalty normally in count 4 would be 93 days in jail and or $500 in fines. However, there is a second offense notice. It says, take notice that the defendant was previously convicted of assaulting or assaulting and battering his or her spouse, former spouse, an individual with whom he had a dating relationship, an individual with whom he had a child in common, or a resident or former resident of his household, or of knowingly assaulting a pregnant individual by violating MCL 750.812 on March 23rd, 2022, and therefore upon conviction will be subject to an enhanced sentence under MCL 750.814. That enhances the domestic violence to misdemeanor, maximum penalty 1 year and or $1,000 in fines, and a consecutive sentence can be imposed if the assault was committed in a place of confinement. You understand the charges there and the maximum penalty there.
No, ma'am.
What part do you misunderstand?
Aware of only 2 charges.
Excuse-
It's 2.
You said what?
I was only aware of 2 charges. I don't know where these extra 2 extra charges come from.
Okay. Well, I didn't ask you if you knew where they came from. My job is to read the charges to you to see if you understand what was read and understand the maximum penalty. Did you understand what was read and the maximum penalty?
Yes, ma'am.
Okay. I have another complaint here. This is a misdemeanor complaint. This complaint alleges that on or about September 1st, 2024, at the area of 1421 East Kalamazoo, apartment 16, City of Lansing, Ingham County, State of Michigan, that you allegedly committed the act of assault or assault and battery upon a Victoria Velez, an individual with whom you had a dating relationship. And there's a second offense notice there as well. That would enhance your maximum sentence on this count 1 of domestic violence to 1 year and or $1,000 in fines, and a consecutive sentence could be imposed if the assault was committed in a place of confinement. So you understand the charge in that file as well,
Yes,
sir,
yes,
and the
ma'am.
maximum penalty. So you have two separate files, but one of the files, sir, you have 4 counts. You understand that?
Yes, ma'am.
Okay. You have the right to an attorney. Mr. Nickel will represent you today, but you have the right to have an attorney represent you at all of your court dates and appearances. And you have the right to have an attorney represent you if you're questioned by law enforcement. If you can't afford to hire an attorney, you can make a request to have the public defender's office appointed at the expense of the public. You have the right to remain silent. Anything that you say, anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute, but if you stand mute, the matter will continue all the way to jury trial. In the felony file, you have the right to preliminary examination, and you have the right to have that examination within 21 days of today's date, the date that you're being arraigned, unless you waive that timeline or the court finds good cause to go beyond the 21 days. You have the right to require the prosecution at the time of your exam to put forth evidence that would suffice probable cause that a crime was committed and probable cause sufficient to charge you with the crime. In both files, you have the right to jury trial. You have the right to be presumed innocent until proven guilty. You have the right to require that the prosecution prove your guilt at trial by first proving each element of the charges being brought against you beyond a reasonable doubt. You enjoy the right to remain silent at your trial and not have that silence be used to prove or imply that you're guilty. You have the right to waive your silence and testify at your trial if you'd like. You can subpoena witnesses that could testify for you. You can put forth evidence at your trial that will show a defense to the charges being brought against you. Do you have any questions about those rights?
No, ma'am.
You are currently scheduled for probable cause conference before me, Judge Kristen Simmons. It's going to be on September 13th at 9 o'clock in the morning. You have a preliminary examination before me, September 20th, in person at the court, 9:30 in the morning. You also, in your other file, have a pre-trial, but that's before Judge Stacia Buchanan. It's going to be September 16th at 9:30. Did you get your notices to appear for those dates?
Yes, ma'am.
Oh. Are you currently on probation or on parole?
No, ma'am.
Is he requesting court-appointed counsel?
He is, Your Honor.
The court will enter a plea of not guilty on both files. Sir, what's your address?
3922 Harford Road.
That's the address of the alleged victim. So where are you gonna stay during
No,
this matter?
She don't stay there no more. She stay on 1421 East Kalamazoo Road.
Okay. You're in apartment 14 on Hartford.
Yes, ma'am.
Are you employed?
Not as right now, doing side work.
What's your phone number?
314-913-7853.
You can address bond counsel.
Yes, Your Honor, I did have a chance to speak with Mr. Felton this morning. He did inform me that he does have prior criminal history, which includes some felony convictions. Appears from reviewing his record that his last felony conviction was in 2017, so approximately 7 years ago. He's resided in the Lansing area for approximately 3 years. The address on Hartford Road, he informed me that him and his cousin reside there, but that the alleged victim in the cases does not. He was not on probation or parole at the time of the offense. I would just ask the court consider a personal recognizance bond or a 10% bond in this matter to allow Mr. Felton to have the possibility of being released while these cases are pending.
Okay, I have here a bond recommendation in the felony file. It states here that there's a concern for the protection of the public, that the defendant at the time that this was issued was either on parole, probation, or had other pending criminal charges, and that the crime charged involves violence towards another person, that the defendant has a history of violent behavior directed towards this alleged victim, and that the history of threatening or harassing behavior towards a victim or witnesses also exists. It says there's an escalation of violence or risk-taking over time, and that the defendant attempts to isolate or prevent reporting. It states here, the defendant was out on bond at the time that this recommendation was drafted for domestic violence with the same victim. During the last Zoom pre-trial conference, the defendant was next to the victim off camera to make sure she said the things right. Defendant got angry at her in this incident when she said he couldn't put his hands on her anymore. He then punched her, broke her phone once she tried to call 911, and held the knife to her throat. The defendant possesses significant risk to the victim, even with bond conditions in place. The people are requesting 75,000 cash surety bond, GPS tether, victim notification.
That's pretty much what we do.
You have something that you wanted to share, sir?
No, ma'am.
Okay, I'm reviewing the criminal history. I see one other domestic violence conviction, which was indicated obviously in the complaint. I also see from 2023, last August, another domestic violence that was charged, which is likely what they were referencing for in their bond report as another matter pending. Due to the allegations, I don't believe personal recognizance bond is appropriate. The court's going to issue a bond of 15,000, 10%. While out on bond, you'll have to be on GPS tether with victim notification. You're not to possess a firearm, weapon, or or ammunition of any kind. You're not to engage in any assaultive or threatening behavior. You're not to use alcohol or drugs without prior showing the court a prescription. You need to report to pretrial services within 48 hours of release. You're not to have contact directly or indirectly with Victoria Velez. That means you can't call, text, message, DM, smoke signal her, or make any communication with her, or have anybody else do those things on your behalf. Do you understand that?
Yes, ma'am.
Do you have any questions about that?
No, ma'am.
On file, or the new file that I don't have the number on, your bond in that matter is set at 10,000, 10%. All the same bond conditions will apply on that file as well, including GPS tethering and no contact order. Do you understand?
Yes, ma'am.
Do you have any questions for the court?
No, ma'am.
Additional matters for the record, counsel?
Nothing further, Your Honor.
You're all set, sir. On the record in the matter of the people of the state of Michigan versus Alan Wisman. Counsel appearance.
Assistant Public Defender Scott Nichol on behalf of Mr. Wisman for arraignment today.
You're Alan Wisman?
Yes, ma'am.
Okay. Mr. Wisman, I have here a felony complaint alleging that on or about September 1st, 2024, at the area of South Washington and South Street, City of Lansing, Ingham County, State of Michigan, he did allegedly commit the act in count 1 of weapons carrying concealed, and that you allegedly carried a dangerous weapon, that being a pistol, whether concealed or otherwise in a vehicle operated or occupied by said defendant, that vehicle being a Chrysler 200, and that this is contrary to MCL 750.227. That's a felony, a maximum penalty 5 years and or $2,500 in fines and a mandatory forfeiture of the weapon or device. Count 2 is weapons, firearms possession by a prohibited person, alleging that you possessed, transported, carried a firearm when ineligible to do so because you have been convicted of home invasion 2nd degree, which is a specified felony that is punishable by imprisonment of more than 1 year, and the requirements for regaining eligibility have not been met, contrary to MCL 750.224 F6. That's a felony, maximum penalty 5 years and or $5,000 in fines and mandatory forfeiture of the weapon or device. There's a count 3, weapons, felony, firearm, alleging that you did carry or have in your possession a firearm, that being a pistol, at the time that you committed or attempted to commit a weapons, firearm possession by prohibited person, contrary to MCL 750.227B. That's a felony, maximum penalty 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction, and again, a mandatory forfeiture of the weapon or device. You do have a habitual offender, 3rd offense notice here. It says, take notice that the defendant was twice previously convicted of a felony or attempt to commit a felony in that on or about June 5th, 2019. He was convicted of the offense of larceny from a motor vehicle in violation of MCL 750.356A1 in the 30th Circuit Court for Ingham County, State of Michigan. And that on or about June 6, 2018, he was convicted of the offense of home invasion 2nd degree in violation of MCL 750.110A2 in the 30th Circuit Court for Ingham County, State of Michigan. And therefore, the defendant is subject to the penalties provided by MCL 769.11, which makes the penalty twice the maximum sentence on the primary offense or the lesser term, and the maximum penalty cannot be less than the maximum term for the first conviction. Do you understand the charges read in counts 1, 2, 3, and the habitual offender third offense notice and the maximum penalty, sir?
Yeah, I understand.
Okay, you have the right to counsel. Mr. Nichol will represent you today for your arraignment, but you have the right to have an attorney represent you at all of your court appearances. And you have the right to have an attorney with you to represent you if you are questioned by law enforcement. If you can't afford to hire an attorney, you can make a request to have a public defender. You understand that?
I do.
Is he requesting counsels, Mr. Nichol?
He is, Your Honor.
Okay, Mr. Wisman, you have the right to remain silent. Anything you say and anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty or you can stand mute. If you stand mute, we'll continue this matter all the way to your jury trial. You have the right in this matter for a preliminary examination within 21 days of today's date, unless you waive that timeline or the court waives it by finding good cause to go beyond the 21-day timeline. At your preliminary examination, you have the right to require the prosecution establish that they have sufficient probable cause that these crimes were committed and probable cause sufficient to charge you with these crimes. You have any questions about that so far?
No, I don't.
You're currently scheduled for a probable cause conference, actually, Mark. You have a probable cause conference before Judge Cynthia Ward. It's going to be on September 13th, 2024. It's at 9 o'clock in the morning, and you can appear via Zoom or in person for that. You have a preliminary examination before Judge Ward. It's going to be September 20th at 9 a.m. Did you get a notice to appear for those dates?
Yes, I do.
Okay. You have the right to proceed to trial. You have the right to jury trial. You have the right to remain silent at that trial and not have silence be used against you. You enjoy the presumption of innocence, so that means, sir, that you're innocent until proven guilty. You have the right to require the prosecution prove your guilt at trial by proving each element of each of the charges being brought against you beyond a reasonable doubt. You have the right to see, hear, or question any other witnesses called to testify against you. You can call your own witnesses to testify at your trial. You can waive your silence and testify on your own behalf and present evidence at trial that you believe show a defense to the charges being brought against you. Do you have any questions about any of your rights?
No, I don't.
Are you on probation, sir?
No, I'm not.
Are you on parole?
No, ma'am, I'm not.
Are you employed?
No, ma'am.
Where do you live?
1102 Persons Court, Pennsylvania.
Can you spell that?
Like Person.
What's your phone number?
Don't have one.
Okay. And is there an apartment at Person Court?
No, that's it's a house.
You're currently on bond on another matter?
Yes. I also have a tether room too.
So you could potentially have a bond violation then, correct?
Yeah.
You can address bond counsel.
Yes, I did have a chance to speak with Mr. Wisman. He did inform me he's on bond and on tether. He has been a resident of the Lansing area for approximately 21 years. Did not report a history of failing to appear for court. I would ask that the court consider a reasonable 10% bond, as it is likely he will end up with a bond violation once Judge Jamo is notified of the new charges.
Bond is set in the amount of 5,000, 10%. While out on bond, you're not to possess, purchase any ammunition, firearms, or weapon of any kind. You're not to travel outside the state without prior approval of the court. You're not to use alcohol or drugs without a valid prescription. You're not to engage in any assaultive or threatening behavior. You must report to pretrial services within 48 hours of your release. Do you have any questions?
My bond is, again, can you say it again?
5,000, 10%.
All right.
Any additional matters for the record?
No, Your Honor.
You're all set, sir. This is the matter of the people of the state of Michigan versus Lucio Pena. Council appearance.
Assistant Public Defender Scott Nick on behalf of Mr. Pena for arraignment today.
Okay, Mr. Pena, I have a felony complaint that alleges that on or about September 2nd, 2024, at the area of Waverly Road and Old Farm Road, City of Lansing, Ingham County, State of Michigan, you allegedly committed the act in count 1 of controlled substance, possession of cocaine, heroin, or other narcotic less than 25 grams. The allegations are that you did knowingly or intentionally possess less than 25 grams of a mixture containing the controlled substance heroin, and that this was contrary to MCL 333.74032AV. That's a felony with a maximum penalty 4 years and or $2,500 in fines. There is an habitual offender fourth offense notice. It says take notice the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about April 2nd, 2007, he was convicted of the offense of manufacturing, delivering marijuana in violation of MCL 333.74012D3 in the 8th Circuit Court for Montcalm County, State of Michigan. And that on or about May 28th, 1999, he was convicted of the offense of unarmed robbery in the 9th Circuit Court in Montcalm County, State of Michigan. And that on or about December 18th, 2018, he was convicted of the offense of receiving or concealing stolen property motor vehicle in the 17th Circuit Court for Kent County, State of Michigan. Therefore, defendant is subject to the penalties provided by MCL 769.12 that would enhance the maximum sentence to life if the offense, the primary offense, had a penalty of 5 years or more, or 15 years or less if the primary offense has a penalty under 5 years. The maximum penalty cannot be less than the maximum term for the first conviction. You understand the charge and the maximum penalty and the habitual offender fourth offense notice, sir?
Yes, I do.
You have the right to counsel. Mr. Nichol will represent you today. And if you need to have an appointed attorney because you can't afford to hire an attorney, you can make that request today to have court-appointed counsel appointed to represent you. You understand that?
Yes.
Is he requesting court-appointed counsel?
He is, Your Honor.
You have the right to remain silent. Anything you say, anything you put in writing can be used against you, sir. You can plead guilty, you can plead not guilty, or you can stand mute by right. If you stand mute, however, the matter is going to go all the way to your trial, okay?
Yes.
Okay, you have the right in this matter to preliminary examination within 21 days of today's date. And you have the right at that exam to require the prosecution put forth evidence to show that they have sufficient probable cause that a crime was committed and sufficient probable cause to charge you with the crime. You have the right to have that within 21 days unless you waive your 21 days yourself or the court finds good cause to go beyond 21 days. You're scheduled for probable cause conference before Judge Cynthia Ward, September 13th at 9 o'clock in the morning. You can appear via Zoom or in person. You have a preliminary examination before Judge Ward in person at the court September 20th at 9 a.m. You should have received a notice to appear for those dates. Did you, sir?
I believe so, yeah. Yes.
Okay, very good. You have the right to trial in this matter. You have the right to jury trial, and you have the right to the presumption of innocence. You're innocent until proven guilty, and you have the right to require the prosecution prove your guilt at trial by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to remain silent at your trial, and they can't use the silence against you. You can waive your silence and testify on your own behalf at trial if you like. You have the right to subpoena witnesses to your trial that will testify for you. You have the right to put forth evidence at trial that you believe show a defense to the charges against you. And you have the right to confront in court and cross-examine any other witnesses called to testify. Do you have any questions about your rights?
No.
Are you currently on probation or parole?
No.
The court's going to enter a plea of not guilty on your behalf. Let's see. Are you employed?
I was going through training to MetroNet, but I'm not currently employed.
What's your home address?
4751 West Strange Highway, Mulliken, Michigan, 48861.
And your phone number?
517-597-0241 or 149 0241. Yes.
You can address the bond counsel.
Yes, Your Honor, I did have a chance to speak with Mr. Pena. He did inform me he's been residing in the Mulliken area for the past 10 years, resides there with his wife and one of his children. I would ask the court consider a 10% bond in the matter. In reviewing Mr. Pena's criminal history, does appear he has an active warrant out of the Saginaw Chippewa Tribal Police Department, and so if he were to get a PR bond, he maybe end up incarcerated in another county. So I think it's appropriate for the court to enter a 10% bond, so he's earning credit.
How far is Mulligan from here, folks?
It's like 20 minutes. It's just west of Grand Ledge. I was born and raised in Lansing.
Okay, sounds good. Bond will be set in the amount of 2,010%. While out on bond, you have the following conditions. You are to report to pretrial services within 48 hours of your release. I am going to order that you participate in substance abuse testing and monitoring while out on bond. You're not to possess a firearm or any other dangerous weapon. You're not to travel outside the state without prior approval of the court. You're not to use alcohol or drugs without a valid prescription. Do you have any questions, sir?
No.
Any additional matters for the record, counsel?
Nothing further, Your Honor.
You're all set, sir.
Thank you.
On the record in the matter of the people of the state of Michigan versus Chenise Glasow. Counsel appearance, please.
Yes, Assistant Public Defender Scott Nickel on behalf of Ms. Glasgow.
Okay, Ms. Glasow, I do have a misdemeanor complaint here that I'm going to arraign you on. The allegations are on or about September 1st, 2024 at the area of 1917 William Street, City of Lansing, Ingham County, State of Michigan, that you committed the act of malicious destruction of a building, $200 or more, but less than $1,000 in a domestic relationship. The allegations are that you did willfully and maliciously destroy or injure a building or its appurtenances located at 1917 William Street that belonged to a Richard Norman, an individual with whom you had a dating relationship, and the amount of the destruction or injury was $200 or more, but less than $1,000, contrary to MCL 750.3805A. That's a misdemeanor. Maximum penalty is 1 year and or $2,000 or 3 times the amount of destruction or injury, whichever is greater. Do you understand the charge and the maximum penalty, ma'am?
Yes, ma'am.
Okay. You have the right to counsel. If you can't afford to hire an attorney, you can have a public defender appointed to represent you at the expense of the public. So Mr. Nickel will represent you today. But again, you have the right to have an attorney with you at all of your court appearances, and you have the right to have an attorney represent you if questioned by law enforcement. You understand that, right?
Yes.
She's requesting court-appointed counsel.
She is, Your Honor.
The court will enter a plea of not guilty on your behalf. You have the right in this matter to proceed to trial, and you have the right to jury trial. You have the right to be presumed innocent until proven guilty. You have the right at your trial to remain silent and not have silence be used against you, or you can waive your silence at your trial and testify. You have the right to confront in court and cross-examine any witness that's subpoenaed to testify against you. You have the right to call your own witnesses to trial to testify on your behalf. or present evidence that you believe show a defense to the charges being brought against you. Do you have any questions about those rights?
No, ma'am.
You will be scheduled for a pre-trial conference. We don't have the date today, but we'll get that to you in the mail. What is your home address?
I currently don't have active address. I'm staying in the shelter, Eve shelter right now, and get back on my feet.
Okay, are you unemployed or are you employed?
Unemployed.
Do you have a phone?
Yes.
What's your phone number?
517-328-8742.
Are you currently on probation or parole?
No, ma'am.
Have you missed court before?
No.
Can you repeat your answer? I didn't pick up.
No, ma'am.
You can address bond counsel.
Yes, Your Honor. I did have a chance to speak with Miss Glasow. She did report she's been a resident of the Lansing area her whole life. She did not report ever failing to appear for court. And when I ran her criminal history, the only thing that I found was a misdemeanor driving offense. So I would ask the court to consider a personal recognizance bond at this time.
Bond is set in the amount of 1,000 personal recognizance, and a no contact order will be in place for the protection of a Richard Norman. So you're not to have contact directly or indirectly with Richard Norman. Do you understand that?
Yes, ma'am.
You're not to be within 1,500 feet of wherever he is. Do you understand that?
Yes.
You're not to engage in any assaultive or threatening behavior. You're not to purchase or possess alcohol or drugs without a valid prescription. You're not to travel outside the state without prior approval of the court. You're not to use, purchase, or possess any weapons or firearms. I'm not sure if mail can actually be directed to you at the Eve shelter. So what I am going to require is that you appear to the court. I'm requiring that you appear to the court within 48 hours to get your next court date, okay?
I can get my mail there. I'll get my mail out the shelter already.
I appreciate that. So one will be mailed there, but I'm going to note in the file that you have been required to report in 48 hours to get your court date. Because what you won't be able to do now is to say you didn't get the mail. Because I'm putting the responsibility back on you, okay?
Yes.
Do you have any questions?
Yes.
What's your question?
There's already a no contact order. I already have a no contact order against Richard Norman. We already have prior assault case. Already we had court this prior Friday.
Where?
He had court, I didn't show up, I was subpoenaed to go to court. There's already a no contact order against him, because we already have 2 prior assault cases against him.
Okay, so what you're saying, if there was a case where you were the alleged victim, there was a court date and you didn't show up.
Yes,
So that case potentially could have been dismissed because you didn't show up.
they rescheduled it, it's new court date, September 26th, that I'm gonna appear to.
Okay, so that means there's a no contact order. He was not supposed to be within a certain space of where you are, but now there's a no contact order protecting him. You're not to be within 1,500 feet of where he is.
Okay,
You have any other questions?
no, ma'am. Yes, I do. Yeah, I do have a question.
Yes.
I have some belongings of me and my sons at his residence I have to get. I would like to get it. I would like to get me and my son's belongings when I get out of jail.
What
his-
belongings? What belongings do you have there?
I have a few clothes. I have my son's shoes. I have food there that I need to get. I have my things of my son's that I need to get from his residence.
You told me you were staying at a shelter though.
I just started shelter, but I've been at my boyfriend's house before then. So I lost my house June 30th. I got evicted from my
You
house. So I've
say,
been at my
when you say your
house.
boyfriend's house, are you talking about Richard Norman or someone else?
Richard Norman.
Okay, and so you're staying at the shelter with your child?
Yes, I just started the program. Yes.
And you have some personal items at the address on William Street. You need to go with law enforcement in order to get them, otherwise you can't get them.
So, okay, so, call law enforcement when I get there, or what I'm supposed to do?
No, you don't go there unless you're going with law enforcement. If you go there without law enforcement, you're gonna get arrested. Do you understand that?
Yes,
So that it's very clear, you're not to be at the address of 1917 William Street for any reason, otherwise that'd be a violation of your bond. However, I will allow you to go once, accompanied by law enforcement so that you can get your personal items, okay?
yes.
Do you have any questions about that?
No, ma'am, no questions.
Okay, any questions about anything else?
No, ma'am.
Okay, you're all set. And don't forget that you need to come by the court within the next 2 days to make sure you have your next court date, okay?
Okay.
You're all set.